Welcome, and thank you for joining us for Hunton's webinar on the key privacy considerations for reopening businesses in the EU. I'm Lisa Soto, and I chair Hunton's Privacy and Cybersecurity practice. And today's program is especially relevant as EU member states are gradually lifting their containment measures, and companies are now putting in place measures to reopen their businesses. And of course, this includes measures aimed at limiting the further spread of COVID-19. Those measures often have data privacy implications, and today's program will focus on how to ensure workplace health and safety in compliance with the GDPR. So this is a quick hit webinar today. We're going for 30 minutes. We may not have time to answer all of your questions, but if you have questions, do feel free, please, to email them to the panelists and at the end of the presentation, and we will get back to you. And also note that the webinar is being recorded, and we will make the recording available following the program. So I'd like to introduce our two panelists for today. François serves as counsel in the firm's Brussels office, and she has more than a dozen years of experience addressing complex privacy issues and advising on a huge variety of EU and international data compliance projects. She often manages GDPR compliance projects, and she represents clients before the CNIL, the French Data Protection Authority. And in two recent publications, Claire addressed the French DPA's response to COVID-19 and its impact on privacy considerations for employees. We also have with us for today's program Léonard, and Laura is an associate in our Brussels office. She advises clients on various EU data protection and privacy issues, of course focusing on the GDPR, and she has advised on CCTV, whistleblowing hotlines, employee monitoring, and the like, and she is also deeply familiar, as we all are now, with COVID-19 privacy issues. So let me turn it over to Claire to kick off our program.
Many thanks, Lisa. I'm sure that some of you have asked yourself the following question. As an employer, can I collect health information from my employees and visitors to limit the spread of the virus within my organization? What information can I ask for, and in what situation? Do I need consent for that? Some of you also may have considered or are considering conducting temperature check, and you may wonder what to do to comply with data protection law. In that respect, an additional common challenge for global organizations has been the need to ensure consistent measures for all their global entities when the data protection guidance differ from country to country. And this is particularly true in the EU, where EU data protection authorities, DPAs, have issued guidance that may diverge quite significantly on some practices. In today's program, we will present the latest position of some EU DPAs on the collection of health information or questionnaires and temperature check. We will then draw some general conclusion from that guidance on what employer can or cannot do in each case. Speaking of DPA guidance on the collection of health information, Laura, could you please let us know where we stand on this? What is the latest position of DPAs, for example, in France, in Germany, the Netherlands, or Spain?
Thanks very much, Claire. Well, let's first take a look at France. In France, the French DPA, the CNIL, confirmed that employers may only process data, including health data, when they receive a report by an employee that he or she is infected or suspects being infected. So what happens is that employees that work in contact with others, such as colleagues or the public, have an obligation to report infection or suspected infection whenever they may have exposed some of their colleagues to the virus. And employers must remind those employees of this obligation. And in that context, employers are entitled to process information that's reported to them by the employees, of course. What employers cannot, however, do is to collect health information from employees in a generalized and systematic way through individual requests or, for example, surveys. But in the event of a report from an employee, employers are allowed to process the date and the identity of the person suspected of being exposed, the fact that the employee indicated that he or she was infected or suspected being infected, and the organizational measures that were implemented by the employer. So, for example, teleworking or referring the employee to the occupational doctor. So that was for France. In Germany, according to the guidance from DSK, which is an association of German DPAs, employers can collect personal data, including health data, from employees and visitors in order to prevent or limit the spread of the virus. This would include information as to whether the employee or the visitor is infected or has been in contact with an infected person, or whether the employee or visitor has stayed in a risk area during the relevant period, which is generally during the incubation period. So for COVID-19, that would mean the last 2 weeks. And by the way, the risk areas have been specifically defined by the Robert Koch Institute, which is a governmental scientific institution. So that was Germany. Now, the Dutch DPA has taken a stricter approach to health collection, to health information collection by employers for COVID-19 purposes. In the Netherlands, employers are not allowed to collect health information about employees or visitors, as this can only be done by the company doctor or the occupational health and safety provider when there is a need to collect data about sickness or symptoms. And to the extent an employee would voluntarily report that he or she is sick, employers in the Netherlands may also not record or share the cause or the nature of their illness. So yes, a stricter approach in the Netherlands. And finally, in Spain, employers can collect health information of employees and visitors, including information about symptoms or visits to risky countries in the last 2 weeks, but that can only happen if it's necessary to guarantee the employees' health and allow the competent authorities to take necessary measures to ensure their health and the health of other staff members, but also to avoid contagions within the company. Very importantly, only specific questions should be asked to employees or visitors. Now, back to you, Claire.
Thanks, Laura. So what are the key takeaways from that guidance and the different views of the EU Data Protection Authority, the DPA? First, as regards the legal basis for the processing of personal data, it is clear that employer can rely on the legal obligation basis. That is to say, the necessity to comply with a legal obligation to which the employer is subject in light of his obligation to ensure the health and safety of his employee or his general duty of care, depending on the member state. With respect to the conditions for processing sensitive data, health-related information here, employer may rely on the necessity to carry out their obligation in the field of employment and social security and social protection law. And this legal basis and condition will allow you to also process visitors' personal data, as visitors will likely come into contact with your employees. In other words, you do not need consent, and in any event, consent would be invalid in the employment context. The second key takeaway from the EU DPA guidance is the importance of data minimization. EU DPAs have stressed the need to limit the data processing and process only personal data that is necessary to comply with your safety obligation as an employer. What does it mean in practice? Well, do not ask questions about the health status of employees who work remotely or in isolation. Limit your question to employees who work in contact with others, other colleagues, and or the public. Also, do not ask those employees to complete extensive and detailed health questionnaires. this will never be allowed. Further, do not ask them specific questions about their symptoms, like whether they have fever or cough, sore throat, difficulty breathing, etc. You do not need to know their symptoms, well, if they may have some, but only whether they are infected or suspect they are. Finally, do not ask questions about the health status of employee relatives. This also will be disproportionate and excessive. The third key takeaway from the DPA guidance is transparency. Be fully transparent about your processing activities and their main feature. So what does it mean in practice? So to the extent that you process personal data, you must provide a notice to your employees and visitors that will contain all the information required by Article 13 of the GDPR. Also inform and/or consult employee representative, if any, or obtain their approval as required by local labor laws. Even if it's not required, it would be best practice to inform employee representatives. The fourth key takeaway is the storage limitation obligation. Again, EU DPAs have reminded organizations of that obligation, that is to say in practice, the obligation to define, to set clear and specific data retention period, and also to ensure that these retention periods are applied in practice. To the best of our knowledge, EU DPAs have not recommended a specific retention period for the processing of health-related information of employees or visitors in the current context. At the EU level, the EDPB, the European Data Protection Board, stated that organizations should consider true needs and medical relevance, so this may include epidemiology-motivated consideration, like the incubation period, and also reminded that the data should be kept only for the duration of the coronavirus crisis. The fifth key takeaway is the necessity to ensure the security and confidentiality of the data that you are currently collecting. And the DPB also reminded the organization of their obligation to adopt, as an employer and also as a data controller, strong security measures and confidentiality policies ensuring that the data is not disclosed to unauthorized parties. In practice, limit access to those employees, staff members who need this information to implement proper organizational measures to ensure safety, workplace safety. Also set up dedicated channels to facilitate employee self-reporting where necessary. And do not reveal the identity of infected employees to other employees. Last but not least, as the EDPB pointed out in this statement of last March, as part of your accountability obligation, the measures you have implemented or you are implementing to manage the current crisis and the underlying decision-making process should be appropriately documented. You can document these measures by conducting a DPA, data protection impact assessment, which would be very likely required, and also make sure that you maintain records of your COVID-19 relating data processing activities, just like you maintain records of your usual HR processing activities. With that, I will turn it over to Laura to tell you more about temperature check. But before, here is some practical information if you are seeking for a CLE credit.
Let's now look at temperature checks. Most DPAs in the EU have provided guidance on whether and how to conduct temperature check, and we'll now take a look at some of these DPAs' guidance and provide recommendations based on those. In France, body temperature readings of employees and visitors are prohibited if these readings are recorded in a paper record or using automated data processing. Similarly, automated capture of body temperature through tools such as thermal cameras is also prohibited. So unless explicitly contemplated by a future law, businesses are currently not allowed to perform these types of temperature checks in France. In fact, companies can only perform temperature checks manually upon entry using a manual thermometer, such as a non-contact infrared thermometer, without recording actual temperature readings or any other personal data, and also without reporting that information either internally or externally. So, for example, to the employee's manager. If these conditions are met, then manual temperature checks would not involve any processing of personal data and therefore would not be subject to the GDPR. Importantly as well, temperature checks must not be compulsory, and employees and visitors must have the right to refuse these checks in France. In Germany, mandatory body temperature checks on employees are not permitted, as it has not been considered a suitable measure to detect COVID-19, as it's not the only symptom of the disease. Fever is not the only symptom. And so employers should refrain from collecting health-related data in a systematic and generalized manner. With respect to visitors, however, body temperature checks are allowed to the extent that they are voluntary, that security measures are in place, and that the checks are set up in a way that they are as minimally invasive as possible. Now turning to Italy, which has been severely hit by the virus. In Italy, temperature checks are allowed on both employees and visitors, provided that they comply with the principles of necessity and data minimization, that data subjects are provided with notice, so ensuring transparency, that the data recorded is appropriately secured, and that it is not shared unless sharing is required by applicable laws, such as with public health authorities. Companies should refrain from recording the temperature of all employees and only record data related to those whose temperature is higher than 37.5 degrees Celsius. And the same applies to the recording of the reason to refuse access to the premises. Now, with respect to visitors, the situation is a little bit different, and temperature data should not be recorded, neither should the reason to refuse access to the premises. Finally, those that will be conducting the temperature checks should be clearly identified by the company and be provided with appropriate instructions regarding how to perform these checks. All right, now looking at the Netherlands. In the Netherlands, according to the Dutch DPA, temperature checks on employees and workplace visitors are not allowed unless they are either conducted by the company doctor or if the temperature data is not recorded, stored, or otherwise shared and is not processed using automated means, in which case it falls outside the scope of the GDPR. So this is similar to the French approach. The situation would, however, be different outside of the workplace environment, in a retail context, for example, where stores may consider conducting temperature checks with the customer's explicit and, very importantly, freely given consent. Spain. Let's take a look at Spain before we end with the UK. In Spain, temperature checks are allowed, provided that they're performed based on criteria defined by the competent health authorities, provided also that individuals, so employees and visitors, have the opportunity to respond to the company's decision to refuse access to the premises if the check reveals a higher than normal temperature, and finally provided that the data is not recorded or retained. And finally, let's say a few words about the position of the UK DPA, the ICO. The ICO has adopted a pragmatic approach with respect to temperature checks. In the UK, temperature checks are allowed depending on the nature of the business. If there is a high risk of spread, temperature checks may be considered proportionate. One thing to note about the practical implementation of temperature checks in the UK is that companies that perform those checks may be required to implement a policy document which will explain the company's procedure to comply with basic data protection principle and the company's policies with regard to the retention and erasure of personal data. And the policy document would also need to include an indication of how long the data will actually be retained, and it should be made available to the ICO upon request. So that's it for me on specific positions from some EU DPAs regarding temperature checks. Back to you, Claire.
Many thanks, Laura. As you can see from that overview, temperature checks are highly controversial and raise a lot of privacy issues in the EU. Should you wish to insist on this and implement temperature check consistently across your EU location, here are some recommendations to mitigate risk. First, conduct those checks on a voluntary basis only. Employee and visitor should be able to refuse, or, as the Spanish DPA recommended, at least should be able to have the opportunity to respond to your decision to deny access if the check reveals a higher than normal temperature. Second, refrain from recording temperature data and or other personal data. We have seen the position of the CNIL, the French DPA, and the Dutch DPA. I mean, temperature check without involving any processing of personal data are, of course, fine. But if you record data from a pan-EU perspective, this will raise more issues. Should data be recorded, please ensure that only necessary, limited data is recorded. Define short retention period, and use devices preferably with local storage capability instead of cloud-based solution to avoid the application of EU cross-border data transfer restriction. As said earlier, being transparent is critical. Therefore, please provide advance notice of the temperature check, preferably in writing. You could communicate to all employees who may be impacted by the measures using the usual way of communicating with them. For visitors or guests, you may consider posting a notice at the entrance of your premises, and also use different means to increase transparency, such as website banner, email to customer, etc. In addition, make sure that employee representatives, if any, are on board. This will limit the risk of complaints from employees and thus the risk of enforcement action. More generally, set up your temperature check so that in a way that they are as minimally invasive as possible. The measuring device should not have direct contact with the individual. And finally, and in addition with all the measures as mentioned earlier, such as data security, DPI, etc., ensure that the personnel who will conduct the checks are appropriately trained. If you use a vendor, verify that you have a proper data processing agreement in place. To conclude, if data protection rules should not hinder measures taken in the fight against the pandemic, employers should not also implement those measures without taking these rules into consideration. And in that respect, the position of EU DPAs is constantly evolving. They are currently updating their guidance, and we recommend that you check their guidance frequently, as well as a recommendation from local public health and labor authorities. Many thanks for having joined us for this webinar. Please do not hesitate to reach out to us should you have any questions.